All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. Record should reflect that the state appears this morning by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Wichow, and the defendant Darrell Brooks appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
I object to that, Your Honor. I do not identify by that name and would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights, if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record that
Mr. Brooks, it wasn't the proper time to do that. That's now the third interruption. So,
with all due respect, Your Honor,
Mr. Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done.
But it is my
I have
right
a number of documents that I need to discuss this morning. Mr. Brooks, you do not have a right to interrupt the court.
No,
I will remind you once again of the Supreme Court rule. It's on a yellow laminated, double-sided piece of paper that is before you. I checked, I verified, it is.
I accepted in return
Mr. Brooks, that's yet another interruption. Let me get through this, please.
I just want, for the
You
record,
will have an opportunity when I give you an opportunity. No one else is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
Mr. Brooks, I am going to keep going. You are warned. You need to follow the standards of courtesy and decorum for the courts of Wisconsin. Chapter 62, that's another interruption.
I intend to follow decorum.
This court comes with a history of Mr. Brooks interrupting now. This is day 4, and every day Mr. Brooks has interrupted. It has resulted in Mr. Brooks being placed in a neighboring courtroom so that this court can efficiently, effectively, and with dignity preside over this case here today. I am well aware that's another interruption. I'm well aware. Stop talking.
Which I have the right to do.
I'm well aware, Mr. Brooks, that you object to the name that has identified on the information and all documents in this case. Your objection is noted. It does not need to be repeated. I will make a record right now. The court notes a continuing objection by Mr. Brooks of his name and that he objects to being here. I know he's filed a number of documents previously related to that. Those documents are of record. There's another document that's filed. At least 2 more interruptions just now. I believe I'm up to 8. Mr. Brooks, you're advised that continued interruptions will result in you forfeiting your right to be present in this courtroom, where you'll be taken to the courtroom next door to appear by video and audio means to participate.
To being removed from the courtroom, Your Honor.
That's another interruption.
And you haven't shown me any lawful case law that I can be removed from the court proceedings in a trial and forced under coercion and duress to appear in the trial that I am needed, that I'm trying to express that I have the right to be present.
Mr. Brooks, there's a proper manner in which you raise objections. You have not followed that proper procedure. You are unable or unwilling to abide by simple rules of civility. You interrupt, you don't wait for anyone to finish, and it will result with you being removed from the courtroom. So you are once again reminded of that. I'm going to give a little slack at the moment only because we are not in the presence of the jury. I'd like to go through a couple of things, the first of which is the jail attire. Mr. Brooks, we, meaning myself and the jail, have made arrangements by allowing folks to bring in street clothing for you. You've appeared previously in a suit and tie, very appropriate for a trial. If you no longer have those clothes available, the jail has a supply of clothes that they can also lend to an inmate. The reason we make those arrangements during trial, sir, is because this court has taken a number of steps to shield from this jury that you are in custody. Your hands are not shackled. Okay, there are skirts around each one of the tables. I'm aware of the feet shackles. That's yet another interruption. I'm aware of the shackles on your feet, and that's why the skirts are on your table and frankly all of the tables, right? So that it appears to be the same for anyone coming in and viewing. Again, arrangements have been made for you to appear in street clothes or civilian clothes. I would like you to appear in street clothes, and the reason why, sir, is to reduce or even eliminate even the appearance that you are in custody. And it is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Mr. Brooks, I've had many trials with individuals who were in custody, and when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect, I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media. It's shown every day on the news where I am, what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
Mr. Brooks, did you hear the question that I asked you?
And I respectfully keep the position that I just put on the record.
Mr. Brooks, I will ask you again. Are you willing to go back to your cell or into the jail and put on street clothes?
I do not consent or agree to anything that you just stated, Your Honor.
All right, he did not provide an answer to a very direct question. Let the record be very clear that Mr. Brooks was given multiple opportunities to answer that question. And go back, Mr. Brooks, that's yet another interruption. I will advise you, sir, that at any point in time, if you wish to put street clothes on, I would give you that opportunity to do so. You've already heard it is my preference. You've already heard me advise you regarding the steps that have been taken to shield the fact that you are in custody from the jurors. You refused to answer my question about whether you would go back to the jail. That's another interruption. So based on his refusal and his choice to come, that's another interruption. Based upon his failure to answer my question directly, I will take that as a non-response, but he came to court here today. That's another interruption. I will take that because he's come to court here today in his jail attire, that is a choice that he has made freely, voluntarily and intelligently. No one has forced him to come to jail in those clothes. This court is encouraging him not to. He's appeared previously in his street clothes in what I would describe as a very nice suit and tie, but it is his choice to not do that, and we will proceed accordingly.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you may not, sir. You need to file a motion in order to do that.
So
Mr.
the
Brooks?
motions I filed haven't even been responded to. I gave
Mr. Brooks, you're interrupting me yet again.
You just weren't speaking.
All right,
so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the other courtroom.
I don't consent to that.
I have had a dozen or more interruptions. We'll be off the record while we do that. Thank you, everyone.
I don't agree to a stop. I'll move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I do not. I have a right to be present for trial.
Yes. Okay. You're able to see the screen, is that right? Okay. Yes. I'll publish that as well. All right, we are back on the record. Appearances are as they were before. I need to make a record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. On every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case. I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items. I want to give him headphones since he has claimed in the past to be hard of hearing in one ear, but given his statement that he would throw and break things, unless he can pledge to this court that he will not do that, I'm not going to provide that information. I will advise that the audio in that courtroom should be turned up accordingly so that it is louder than it has been. I've also been advised that the audio and visual equipment is working in that courtroom. The deputies that are in there can see and hear the court through the Polycom system. Today is a little bit different in that there is no Zoom. And so, but this court, with the blessing of technology in this new building, have the ability to call in one room system to the other. That is why we're able to see and, when appropriately, hear him when unmuted. And then there are the 4 camera angles that are presently from this courtroom. I have the camera in the other courtroom on a single camera since he's the only individual in there. This court has, in essence, extended this courtroom to the neighboring courtroom. While there is ample evidence in the record, not only through the proceedings up to this point, but this morning alone, that through his conduct, he has forfeited his right to be present. I'd also make a finding that he is appearing from that courtroom, and that because of the audio and visual equipment and system that we have in place, that it is the functional equivalent of being present in this courtroom. This court has relied repeatedly on Illinois versus Allen. I've read portions of that case into the record. I don't intend to go through that at length here today, other than to indicate that Trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula exists for maintaining the appropriate courtroom atmosphere will be best in all situations. And in that case, there were at least 3 constitutionally permissible ways for a trial judge to handle a stubbornly defiant defendant, which this court would find Mr. Brooks squarely has become and has demonstrated over the course of these last few days. One option is to bind and gag him. I've already talked about at a previous hearing why I choose not to do that. Cite him for contempt. I choose not to do that either. The third is to take him out of the courtroom until he promises to conduct himself properly. Mr. Brooks today, of course, showed up in court from the jail in his jail attire. He does that by his choice. I gave him the opportunity to go back to the jail to put on his suit and tie or other street clothes. He refused to answer that question. This court will continue with this trial, as I have previously indicated. There are many resources that have been put into bringing this day to bear, and it is important for all involved that this trial continue. Again, Mr. Brooks is given the opportunity to appear from that other courtroom. At this point, I'm still in the final housekeeping matters, and so he clearly has forfeited his right to be present for that. I will advise Mr. Brooks, as I have advised him repeatedly, if at any point in time he wants to come back and he is willing to promise that he will abide by the rules of courtesy and decorum and be civil and show respect for the court proceedings for all individuals in this courtroom, including Mr. Brooks himself, then he may come back in. It's also my intention to give him that opportunity at each new stage. But again, we are in the preliminary stage prior to the jury being brought in. I would note it's a little after 9:06 a.m. At all times throughout the court's statements thus far, since going back on the record, Mr. Brooks still appears to be communicating, or at least attempting to communicate with someone else. I can see his hands moving. He has turned his back. I can tell that he can hear me because he shakes his head no. At a point in time where it's clear he's disagreeing with something that I've said, I believe he can adequately hear, and that his statement earlier in the proceedings that he's hard of hearing is simply another tactic of his to disrupt, to delay, to create chaos. I will further advise Mr. Brooks that his continued behavior, whether it be appearing in court in jail attire, whether it be causing disruptions in front of the jury, that he does all of those things at his peril. But I will, of course, take appropriate steps to limit what the jury can hear, if appropriate. All right, I've received a note we need to reset the Polycom system, so I'm not sure what that means. I'll find out, and if appropriate, make a record as to why and whether that impacted anything that was happening in the other room. But at this point, while I'm not going to get off the bench, we're going to take a short recess for that resetting to take place.
I would request an opportunity to be heard then, Your Honor, when we go back on the record, please.
Absolutely. I received was that all of a sudden the audio was only going through 2 speakers and not all of them, A simple reboot of the Polycom system over there took care of that, and I have confirmed that it's working properly. Before I turn to you, Attorney Opper, because I'm not sure if Mr. Brooks heard this or not, at the very end, before I removed him, I wanted to make sure that the record is very clear. I will note a continuing objection to the issues he raises regarding his name and other things. There are filings that substantiate that. It will be my position it's not needed for him to do that every single day because I've noted a continuing objection. With that, you wanted to make an additional record?
Yes, Your Honor, it's probably appropriate at this stage. I did want to address a topic that's maybe not been raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks to proceed to trial. The court is well aware that the district attorney has an obligation and a duty to raise any concerns as to the competency of any defendant to proceed to trial. Any counsel representing Mr. Brooks would have that same obligation, and the court itself, if it had a concern as to the competency of any defendant to proceed, can request an evaluation that's pursuant to 971.14 of the Wisconsin statutes. At no time has anyone involved in this case had a competency concern, and I say that based on the fact that Mr. Brooks has made multiple court appearances, most of them before Your Honor, but at least initially he appeared before two court commissioners. He's had counsel representing him up until last week on this case, and you've made a record with Attorney Perry previously as to Mr. Brooks' ability to understand what's going on and his ability to participate in his own defense. You made a thorough record last week when you went through his waiver of right to an attorney and his absolute desire that he expressed multiple times to represent himself. I am thoroughly convinced, Your Honor, that Mr. Brooks is 100% competent to proceed to trial, that his mental capacity is not reduced in any fashion. Anybody that thinks otherwise has no involvement with this case. I would reference the court to today's filing, which Mr. Brooks provided. It is extremely well written. His handwriting is immaculate. It's perfect. The punctuation, the grammar is 100% accurate. He drafted this himself in his jail cell last night, I presume. Maybe it was this morning. He has continued with the same objections that he has been making repeatedly in this case, so he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this form notarized by a jail employee so that it is a signed and sworn affidavit. Absolutely no concerns on the part of the state of Wisconsin that Mr. Brooks has any deficiency in his competency. We are 100% convinced that these actions of Mr. Brooks are deliberate and intentional, and they have escalated, and the court has seen this since August 25th or so, as the motions were decided by the court, most of them to his detriment. His behavior became more and more difficult in the courtroom. It started out less aggressive with him sleeping and asking to be able to leave the courtroom. Then we had a toothache. Then we had a situation where he didn't want to come to court, was refusing to come to court. The record will be clear, Your Honor, that each time, and the Sheriff's Department has done an absolutely fantastic job dealing with Mr. Brooks fairly, professionally, respectfully at all times. We concur 100% with the record you just made as to what happened after the recess at about 8:42 this morning as to Mr. Brooks' conduct. These are deliberate actions on his part as we get closer and closer and closer to actually presenting this case to a jury, that he is attempting to derail these proceedings and avoid the inevitable. And I want to make that record. I tell this court, as an officer of the court, we have zero concerns as to the mental competency of Darrell Brooks to proceed, and we have had many, many dealings with him on the record and off the record that I base that on. I also wanted to add one other comment as to the court's record as to the need to proceed with this trial. We concur 100%. We would also note it's not just a matter of resources. It's the need to proceed to justice. It's the need to get justice for the crime victims who have patiently attended every one of these hearings. They have a constitutional right to trial. They have a constitutional right to a speedy disposition of this case. And that doesn't mean hasty. That doesn't mean reckless. It means efficient administration of justice. And this court has provided that to the crime victims. And we think that's another reason that Mr. Brooks' antics, which is all they are, clearly speak for themselves. This is not his inability to understand what's going on by any stretch.
Thank you, Attorney Opper, and I do appreciate you raising that with the court because I share your observations that you've just noted on the record. I would adopt them fully as if they were my own and make them part of the findings that I've already made on the record. Obviously, I personally haven't listened to the jail phone calls that you referenced, but I do take your statements as an officer of the court. I look forward to further reviewing them, if need be, changing any conclusions that I've reached here today, and I would require you to file that exhibit so that that can be part of the record as well. I would also add to what you have just stated. This court has read through not one, not two, not three, but 4 evaluations related to the special plea that was withdrawn. And those are very recent evaluations where the examiners met face-to-face in the jail or in an appropriate visitation room with Mr. Brooks, either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted by those examiners as well. This behavior is frankly more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from a mental disease or defect that would qualify for a special plea. I've not gone into much detail, and I won't. Those documents are part of the record, but it's very clear to this court that everything that he has done, as outlined by the state and as made evident on the record of these proceedings, that it is the sole intent of Mr. Brooks to make a mockery of this process. And I've stated, and I'll state it again, I'm not going to tolerate it, but there is, I believe this trial needs to continue, should continue, not only for Mr. Brooks as the accused, who also has the right to a speedy disposition. He hasn't exercised it. The victims have a right to a speedy disposition. And it's important for the justice system to go forward with this proceeding. We are at the stage where we are at with Mr. Brooks muted in another courtroom because of his defiant actions. No one else. And I appreciate everyone's patience as the court goes through these things, frankly gives Mr. Brooks time after time after time to conform his conduct to the clear expectations, but he just simply flat out refuses to do so. So what I'd like to do is finish with the approval of the jury instructions, the preliminary jury instructions. I will make a record that Mr. Brooks did not file anything in writing regarding a proposed jury instruction, as he was advised to do yesterday if he wanted me to consider something. I believe we had a very clear discussion on the record about that. He was given a full copy of the draft preliminary jury instructions. He was part of that conference that we held yesterday. There was even a discussion regarding where he could find jury instructions with the legal materials that he has access to in the jail. Although he didn't take it to his cell yesterday, he has had the selected statutes that I referenced yesterday that also have the rules of evidence. And so I wanted to make that record. I don't have anything from him this morning regarding any additional jury instructions. Has the state had an opportunity to now review the preliminary jury instructions with all the changes that were made yesterday?
We have.
Any objection to those?
No.
All right. Mr. Brooks, I'm going to unmute and ask you if you have any objection to the jury instructions that were provided to you yesterday. I'm specifically looking for a yes or no answer, and I'll address further if need be based upon that yes or no. The microphone is unmuted. Actually, we'll need to turn him up. It's not very loud on our end. Mr. Brooks, did you say one more time?
I said him on the record.
Yeah, but you know what? Your volume's a little low, so we're gonna have them adjusted over there and in here. So give us a second. I think she's to turn the mic off. Where is the microphone? It looks like it's in front of the monitor. Mr. Brooks? Try again.
Am I on the record?
You are on the record. Ooh, that's loud now. We'll turn ours down. Mr. Brooks, yes or no question, do you have any objection to the preliminary jury instructions that were provided to you yesterday? Go ahead, answer please. All right, your objection is noted for the record, and I'm just putting the mute back on. He provided that objection without any legal basis. I muted him just so I could ask this question. I'll be right with you, Captain. Mr. Brooks, do you have a legal basis to object to those preliminary jury instructions? I'm unmuting you. Hold on, the volume is not being appropriate at the moment. There needs. Try it again, sir. I apologize for the technical issue. All right, the technical, we're going to have to figure that out. It's not appropriately working. I do appreciate that he was able to hear me because he leaned in to answer. So I just want to make that record. I'm going to go take a recess. I'll just mute while we're doing that, just so I can figure out what the audio issue is, and then we'll go from there.